Welcome to A Way Forward, the right to recover.
Welcome to A Way Forward, the right to recover with attorney Craig Robinson. Craig is a partner at Robinson & Casey, PLLC, a Florida law firm focused on behavioral health law, including the Marchman Act and mental health guardianships. He brings a distinctive perspective to this work, combining his legal experience with a background in recovery advocacy and a master in social work. I'm Lisa Mosby, and today we're starting at the foundation, what the Marchman Act actually is, and just as importantly, what it is not. Welcome, Craig. Thanks for being with me.
Thank you, Lisa. This is awesome. Really excited.
It's my pleasure. And, Craig, since this is your first episode, can you share a bit about your background and what led you to focus your legal practice on addiction, mental health, and access to treatment?
Of course. Thank you. I've been an attorney for 18 years, and the first 10 years of that was in civil litigation. And during that time, I struggled with my own addiction to cocaine and alcohol and some mental health issues as well. And so in 2018, I actually entered treatment for addiction and mental health myself. And that kind of started the pathway forward for Robinson & Casey and for our firm today. I ended up going back to school, and I got a master's of social work, as you mentioned, and started learning about the Marchman Act. I came to treatment in Florida, and it's a unique Florida law. So I started learning about it and how it can help families who were going through a similar circumstance to what I was going through when I was suffering with my own addiction. And that's kind of how the firm really formed. And so we've been around now for almost 5 years. And this is all that we do, is represent families who have a loved one with addiction or mental health issues. And we help them to access treatment through the court system.
So many times when we have our own experiences, it makes us more powerful, more committed, and better able to support people. At a basic level, what is the Marchman Act designed to do under Florida law, and why does it exist?
Lisa, the best way I can describe it is that, just taking it back to my own addiction, is that when you're in the throes of addiction, you don't really realize, that there's a better pathway forward. The addiction and your mental health disorders can really take you to a place, and it really took me to this place, where it's really impossible to see that you need help. And part of addiction and part of mental health is that it really lies to you. It causes you to believe things that are not reality. And so the best way I can describe this law, which has been around since 1993, actually, is that it essentially gives families an option when their loved one is so deep in the throes of addiction that they can't see for themselves that they actually truly need the help. And without that help, they are in harm's way. I mean, most of our families, their loved ones are going through things like they've had DUIs, they might be driving while intoxicated, they might have overdosed several times, they might have had to be involuntarily psychiatrically stabilized multiple times in a hospital setting, aggression, neglecting medical conditions, things that truly, if the family doesn't do anything, it's going to likely lead to serious bodily harm, or even ultimately, unfortunately, death. And so what this law really was designed to do, and I mentioned it's been around since 1993, it was actually created by a chaplain, and his name was Hal Marchman, and he actually created, or really kind of was the inspiration for this law. He was in recovery, and really what he recognized was that there were other states, and even Florida, that had a law for someone who was going through a mental health crisis, that it allowed a family or law enforcement or a clinical or medical professional to intervene and to actually involuntarily place that person in a hospital for mental health crises. But what Hal Marchman realized in the early 90s was that addiction was becoming so prevalent, and that there was really no law that really helped a family to intervene on their loved one when they had issues with addiction, not just mental health. And so that was really the inspiration for the law. And really what it does is it allows those families, and it gives them an option similar to those involuntary psychiatric stabilization laws that I talked about, to intervene on their loved one through the court system when they can't see that they need the help on their own and they're in harm's way if they do not get that help. I will just also add that it is a really unique law. There is no other state that has a law quite like it. There are some states that have kind of variations of it that are somewhat similar in nature to it, but there are a lot of things about the law that make it completely unique from anything else that we have in the United States or really in the world. And I will also just add, because of that fact, we have a lot of families that we represent that hear about the Marchman Act from other states and actually bring their loved ones to the state of Florida just because the law is so favorable to a family that's in that position where they have a loved one suffering from addiction and co-occurring mental health disorders. And you don't need to be a resident of the state of Florida to take advantage of it. You just have to have your loved one physically here. So a lot of times families will bring their loved one to the state of Florida just because the law is so favorable to getting their loved one help.
We want to get into the specifics of it, but first, there's a lot of misunderstanding around this law. What are some of the common things the Marchman Act is not, even though people often assume that it is?
That's a great question, too. I'd say probably number one on the top of that list is this is not forced sobriety. And what I mean by that is that a lot of families think that this option is going to automatically solve the issue that their loved one is in. Really what this is because you can't really force somebody to be sober, right? I mean, that ultimately is a choice that somebody has to make, and they have to have the willingness to be sober and to live a sober lifestyle. What this really is it provides an opportunity for that individual to get sober, to develop the willingness to actually be sober and to actually want a better life. As I mentioned, when you're in the throes of addiction, at that point in time, when you're using drugs, alcohol, other substances, or you have a serious mental health condition that's going untreated, as I mentioned, you can't see it in that moment in time. And so it's really hard for an individual to take that first step in getting the help that they need. In my experience, I equate it a lot because I can relate to this so much. The 4 hardest words that I ever said, which was to my father at that point in time, was, "I need your help." And for a lot of addicts and alcoholics and people that have mental health disorders, those are the 4 hardest words for them to ever say. What this law does is it removes the need for them to ask for help, and it actually gets them right to the help. And from there, the willingness has to develop. And oftentimes we see it develop once they're in a clinical setting with really good clinical professionals. So that's number one. I also would say that a lot of families think that this is lockdown treatment is a term that we hear often, because many families are used to other states that have those involuntary psychiatric stabilization laws where you'd be taken to a hospital and you'd be placed in a locked psychiatric unit and you wouldn't be physically able to leave that unit. This is not that. It actually is court-ordered treatment that takes place in a non-lockdown facility, usually private treatment centers that are usually nice, like that either accept insurance, some of them are cash pay. But the best part about it is, I think, is that those individuals are actually commingled with other people that are there in that facility voluntarily who want their own sobriety. The doors are not locked. However, there is a court order in place requiring them to remain in that facility. So a lot of families come to us and they want lockdown treatment, but I oftentimes have to explain to them, that's not necessarily what you really want. What you really want is for your loved one to be in a setting where they're around other people who can inspire your loved one because they want their own recovery, not just a psychiatric unit of a hospital where they're there with all patients who are there against their will. You want them to experience what true recovery and true willingness looks like so that they can start to develop it themselves. And I mean, the last thing that I would say that it is not is, and we could talk about this probably a little bit more in other episodes too, is that they are under the impression that if you don't comply with a Marchman Act order, that you automatically, at the snap of the fingers, go to jail. That is not how this process works. There is a process in place by which there can be consequences imposed, but it is not as automatic as that. There is a process and there are due process rights that somebody under a Marchman Act has to go through before consequences are imposed. And part of the reason really for that is that we don't want someone to experience consequences through this law. We genuinely want them to get well through this law. And so that's why that's kind of a last resort in the process, are consequences. And so those are just some of the things that it is not, and that people might have a misconception about what it is.
You mentioned that people don't have to be Florida residents, that they can bring a loved one here and get help. Who is eligible for a Marchman Act case, and what kinds of situations does it apply to versus situations where it legally cannot be used?
So, first and foremost, is that it applies to anyone physically located in the state of Florida. So, you have to be in the state of Florida. There is really no other requirement as far as who can be Marchman Acted. Really, as long as somebody's feet are on the ground in Florida, they are subject to the Marchman Act. There are other criteria, obviously, at play that ultimately, in the case, have to be proven to the court in order to meet the burden of proof in the case. And so, what I mean by that is somebody has to, first and foremost, have to have lost the power of self-control over a mood-altering substance. That could be alcohol, that could be illicit drugs that someone's purchasing off the street. It can also be prescription medication. A lot of people are getting medication prescribed by a doctor. That can include cannabis-induced products or cannabis-derived products like marijuana. Medical marijuana is legal in the state of Florida. Many people have their medical marijuana card, but that doesn't mean that they can't be abusing that substance just because they have the card. So they have to have lost the power of self-control with regards to their substance use. There has to be a history of lack of compliance with treatment for substance abuse, meaning they have to at some point in time have to at some point in time have had to not follow either the recommendations of a clinician or a doctor or some other medical or clinical professional. They have to be unlikely to voluntarily participate in recommended treatment, meaning we have to give them the opportunity to do it voluntarily. We sometimes get calls, Lisa, from families who are trying to get their loved one to go to treatment. One of the first questions we ask them is, have you asked your loved one, or have you made any efforts to get your loved one to go to treatment voluntarily? And believe it or not, sometimes families will say, no, we've never asked. And so our response always at that point in time is, well, you should start with that conversation before you jump to a legal intervention. And the reason why they call sometimes, Lisa, is that they sometimes having that conversation with their loved one is even more difficult than it would be for them to actually just jump to hiring an attorney and having a legal intervention. But we always tell families, you have to ask your loved one and try to get them to go voluntarily before we can represent you. And the last part of the criteria is that without treatment, the individual has to be at risk of self-neglect, and that self-neglect has to pose a risk of substantial harm to themselves or those around them. And so essentially that is what we have to prove in court. And so that would be those would be the requirements for someone to be placed under a court order via the Marchman Act. I will just also add that the law does account for co-occurring mental health disorders. Most of our cases involve a co-occurring mental health disorder. Sometimes that looks like it could be depression or anxiety, and other times it can involve something like a bipolar disorder or schizophrenia or schizoaffective disorder. But a lot of families will come to us and they'll tell us that their loved one has a primary mental health disorder, meaning they've been diagnosed primarily with a mental health disorder. They might have a component to their disorder that involves substance use, but that might be considered a secondary disorder. That's okay. Even if somebody has a primary mental health disorder, as long as they have a secondary substance use disorder, they can still qualify for the Marchman Act.
And I know some families worry that using the Marchman Act means taking control away from the loved one. How do you frame the balance between personal rights and safety when explaining this law to them?
Yeah, most of our families come in with this concern, Lisa. To be completely honest, it's the fear of the reaction that they might get from their loved one because they're taking some control away from their loved one. And the easiest way I can put it, Lisa, in response to that is, would you rather your loved one be mad at you and here on this earth, or would you rather the alternative? And as harsh as that may sound, that is really the reality of what we're dealing with. And I also have to say that concern, while valid for families to feel that way, most often is not the case. Once someone is under a court order and they're in a facility, and then they have the opportunity to process with really highly trained therapists and doctors why it is my family had to take this step to utilize a Marchman Act, what we more often see is a lot of family healing take place after the dust has kind of settled of the case and the person is under that court order. So it's a completely valid feeling that those families face on the front end. But the reality of the situation is that more often than not, we see some real miracles happen.
And for families who are just learning that the Marchman Act exists, what's important for them to understand before deciding whether it's the right path for their situation?
Yeah, and I would say, Lisa, that the best answer I can give to that question is that if you are a family that feels like you have tried everything else and you feel exhausted because you feel like you've been going through the merry-go-round, as I call it, or even a roller coaster, right? Where I feel like I've tried to get my loved one to go to treatment voluntarily. I've given them every opportunity. Most of our families, their loved ones have been to treatment several times. Even sometimes, Lisa, we had one family that we represented where their son had been to treatment 40 times voluntarily and had never stayed and followed all clinical recommendations. So if you feel like you're on that kind of roller coaster that unfortunately having an addict in the family can feel like at times, I would say that this is a really good option, for you to actually finally put some guardrails on your loved one's treatment. And when they take their will back and decide to leave treatment, that there is some legal recourse, and the best way I can put it is it gives you the ability to close doors that otherwise your loved one would be able to open, and that they would remain open. So, I mean, I also would say just calling us and having that first initial conversation, I think is a huge step for families. And we say in our firm, we've been there. That is kind of our tagline, because both myself and Richard Casey, my law partner, both have suffered from addiction and mental health issues. And so if anybody will understand and empathize with the plight of a family going through this, it's us.
Communication and getting educated. What's available? What options are there? Because there are some to choose from. Thank you so much for today. And that's it for today's episode of A Way Forward, the Right to Recover. If you'd like to learn more about Craig Robinson and the work of Robinson Casey PLLC, including resources related to the Marchman Act and mental health guardianships in Florida, please visit robinsoncasey.com. Thank you for listening. And don't forget to subscribe, leave a review, and please share this episode with someone who may be in need of it today.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.